Hi everyone, my name's David Moore and I'm one of the civil means technical leads employed by the Legal Aid Agency. I've worked at the Legal Aid Agency now for roughly 15 years and today I'm going to take you through some hints and tips when it comes to assessing financial eligibility on civil means. So the first one I would like to talk about is CCMS notifications. Please, we ask, could you check that your CCMS notifications regularly? We send regular actions and notifications through CCMS, and it is in your best interests to check these at regular intervals. We would advise that you check your actions and notifications at least once a week, but depending upon the number of applications you submit to us, you might want to do this more regularly. The more regularly you check your CCMS notifications, the quicker you can pick these up, request the information, and get these back to us. Clients in receipt of an income passport and benefit. Before submitting an application where your client is in receipt of an income passport and benefit, please ensure that you check very carefully that your client is applying for legal aid in exactly the same name that they claim state benefits in, and that their national insurance number is correct. If you could collect evidence of the client's national insurance number, that would help a great deal too. What we find when we look at these applications is that sometimes there might be just one letter out in the client's surname or forename, or a number or letter missing from the client's national insurance number or incorrect within that. Anything like this, once it goes through the benefits checker, won't be picked up. It will not return a positive check. Any discrepancy between the information that the DWP holds and what we've submitted will return in an undetermined check. If you get an undetermined check, that means we will have to contact you and your client and seek further evidence of the client's benefits. Frequency of wages. Entering the incorrect frequency for wages or state benefits can mean that your client will appear eligible for funding when this might not be the case, or that they could be showing as being eligible on a non-contributory basis when actually a contribution from their income and/or capital could be requested. State benefits are usually paid either weekly, fortnightly, or 4-weekly. The only benefit that we're aware of at present that we regularly see which is paid on a calendar monthly basis is universal credit, but at present this is one of the income passport benefits, so it's not an issue really. If you put in that your client receives benefits on a 4-weekly basis, but it's actually weekly or fortnightly, obviously this will have an impact on the assessment. The same goes for wages. Now, wages can be paid on a weekly, fortnightly, 4-weekly, or calendar monthly basis, depending on where they work and who the client works for. So we would just ask that when you collect pay slips from your client, that you just check carefully the period, what period it is that these pay slips cover and the frequency that the client is paid. Housing costs. We require evidence of the current rent and mortgage liability and evidence of the payments made by the client. The easiest way to demonstrate this is if your client pays their rent or mortgage by either direct debit or standing order, to just highlight the corresponding payment on the client's bank statements. If your client pays board and lodgings, then we appreciate this is usually a more informal arrangement and they might not be paid by standing order. This could just be paid in cash each month. If it is paid in cash each month, what we would ask is that you demonstrate on the client's bank statements the withdrawals used to make this, especially if all of the client's income is paid through their account. If all their income goes through their account, then it shouldn't be too difficult for the client to highlight the appropriate withdrawals used to make the net board and lodgings payments. As well as this, we also need a letter from the person the payments are made to, confirming the amount paid and how the payments are apportioned to rent, food, utilities, and other incidentals. For our purposes, we're only allowed to give accommodation-only costs. The reason for this is that this applies to all clients. So if we were to allow a higher amount to say that covers board and utilities for a client paying board and lodgings, we wouldn't reciprocate this for clients who pay rent and mortgage. So they would be receiving deductions that other clients wouldn't. When someone pays board and lodgings, they tend to not have their own utility account at the property. So whatever board and lodgings they pay, even if they pay purchase their own food will contain at least some elements of utilities, which is why we need this letter. Again, the best way to do it will be if you could highlight the corresponding payments on the client's bank statements, especially, again, as I say, if all of their income does go through the account. If the client does pay this in cash and they have some form of income in cash, so they could be self-employed, receiving cash, or they could just be paid in cash by their employer, we need to ensure that they are receiving sufficient cash payments in order to cover this before we could give an allowance within the assessment. If your client is in receipt of housing benefit, then please provide evidence of the amount the client currently receives. If it's received into one of the client's accounts, you can highlight the payments on the appropriate statements. However, if it's paid direct to the landlord, we would need to see an award letter. Whilst we don't take housing benefit into account within the income side of the assessment, when it comes to the deductions, we deduct the client's housing benefit from the gross rent that they pay, and we allow the net amount within the assessment. Bank statements. Bank statements should cover the 3 months preceding the computation date and be collected for all accounts held by your client. This can be sole accounts, joint accounts held with an ex-partner or a current partner, and also any accounts that they are named on as a signatory, such as children's accounts. Statements need to be legible and continuous. They need to have a visible name and account number and show all of the transactions and balances. What we're seeing increasingly now with the new type of accounts that are on the market currently is that clients don't receive regular statements, but instead they will be able to provide screenshots from their mobile phone or from a banking app or something similar. We can't accept these. This is fine, but as I say, it needs to have the client's name and account number contained within the screenshot somewhere, just so we can be sure that this account does belong to your client. Explaining transactions on bank statements. Most further information requests regarding transactions on bank statements relate to credits from unknown sources or transfers to and from undeclared accounts. To reduce further information requests, where possible, please highlight and explain any transactions or transfers on the client's bank statements, particularly when they are marked with the client's name and or an account number that does not correspond to any of the declared accounts, or these relate to regular cash credits or other credits from the same source or individual. Moving on, I'd like to talk about National Asylum Seeker Support, also known as NAS. If you have a client in receipt of National Asylum Seeker Support, please can you ensure that any evidence you upload is dated within the last 6 months. If you provide evidence older than this, we will need to write out and request more up-to-date evidence. So it would be in your best interest if you could get this up front. Negative disposable income. If your client has a negative disposable income, this is where their assessed outgoings exceeds their gross income. You will need to look for any obvious reasons as to why. The two main reasons where a negative disposable income can be explained easily are where your client has a large dependence allowance. So if your client has 4 or 5 children, say, and a partner's allowance, we appreciate that they will not necessarily be paying that exact amount out on each child each month. However, this is a set allowance, and regardless of how much they pay out per child, this allowance is what they are entitled to. If your client has, say, a gross income of around £1,500 a month, but does have a number of children and the dependence allowance is around about that or even exceeds that amount, then this is not to worry about. The second scenario would be in a repossession case where your client has a large rent liability. What we do in the assessment is we allow the rent liability as a deduction, even if the client cannot afford to pay it. So your clients, again, could have a gross income of around £1,500 a month. They have tax, national insurance, employment expenses, dependent allowances, and then a rent liability of around £1,000 per month. In reality, we know that the client can't pay that. But as I say, we must give the rent liability within the assessment. So if this is the scenario, this again is easily explained as to why it appears your client is paying out more than what he has coming in. If neither of the above is applicable, then more investigation into why the client has a negative disposable income will be required. A negative disposable income tends to suggest that either there is some form of undeclared income, such as financial support, or the client is not paying all of the deductions they claim to be. As well as clients with a negative disposable income, this would also apply to clients with a very low disposable income, unless, of course, either the high dependence allowance or the rent liability, as mentioned earlier, applies. If your client has a disposable income of around about 150, say, £200 per month, looking at the assessment itself, we do not give an allowance, as I'm sure you're aware, for any council tax or utility payments, as this is factored into the assessment anyway when it comes to calculating the contribution. So if your client in reality has a disposable income of around 150 to £200, and we haven't given any deduction for utilities, say, especially given the current cost of living crisis that we're suffering at the moment, we appreciate that the client may struggle to pay these other bills, and you would need to investigate further how they were meeting their costs. Childcare. A childcare deduction can be given when the client is absent from home for either work or study. We will consider the usual term time childcare costs. So what this means is that whilst your client's children are at school, if your client incurs childcare costs during this period, then anything they incur we can allow in the assessment, subject to the correct evidential requirements being provided. If the client's childcare costs increase during the school holidays, we do not take into account any increase in their costs, as this is seen as a temporary change in the client's circumstances. If your client doesn't incur any childcare costs during the usual term time, but incurs them during the summer holidays, Easter holidays, Christmas holidays, etc., no allowance can be given, I'm afraid. Subject matter of dispute. When applying the subject matter of dispute allowance, please ensure that this is only applied to assets that are specifically under attack within the proceedings. It is not appropriate for any or all of the client's assets to be lumped together as SMOD. The test for whether an asset is SMOD is the same test we use when it comes to determining whether that item was an issue in the proceedings when it comes for statutory charge purposes. If the statutory charge could not arise against the asset, it cannot be classed as SMOD.
Hi, my name is Jim Peake, and I am a lead means assessor for the Legal Aid Agency. I've worked for the Legal Aid Agency for 25 years, and I've been a civil means assessor for most of that time. Today, I'm going to be talking about trapped or inaccessible capital, which is obviously a relatively new topic for those people involved in legal aid. So in January 2021, a new process was introduced whereby legal aid providers could make the argument that assets owned by their clients were in essence trapped or inaccessible. This followed the ruling of Mr. Justice Pepperell in the case of R/GR versus Director of Legal Aid Casework. The key points emerging from this judgment were as follows. A fixed system for the valuation of interest in land, ameliorated only by fixed sum disregards, would prevent some people on low income who cannot access equity in their homes from having fair and effective access to justice. The director has discretion under Regulation 31B to value assets other than money in an equitable way. And that could mean valuing them in a way that they effectively had no value for the purpose of a legal aid financial eligibility test. In terms of practicalities, if you need to make a trapped or inaccessible capital argument, please take the two-pronged approach as follows. So the first prong is you will need to confirm why the assets in question are trapped. If it is property and it's held in joint names with the opponent, you may well be able to argue that the property is effectively unavailable to the client as a potential source of capital, because the opponent would have to agree to any further monies being borrowed against it, and there is obviously pretty well zero probability of them agreeing to that. Depending on the client's income position, you may also be able to argue that they will be able to borrow money, that they would not be able to borrow money in any scenario, particularly if they're in receipt of an income passporting benefit or they have a low disposable income. The second prong you need to consider is whether the client's convention rights would be affected if they were to pursue litigation without any legal representation. Arguments around Articles 6 and 8 would normally be cited here, and by way of example, if you have a client who is seeking an injunction, you would be able to argue that it would be completely inappropriate for a client to have to potentially examine their opponent in court. So that gives you the two prongs that you need to follow if you want to make a trapped or inaccessible capital argument. In terms of how to submit your argument, we would prefer you to use the further information section at the bottom of the means report, or as an alternative, upload a separate document outlining the arguments around the trapped or inaccessible capital. That will make it easier for caseworkers to identify the trapped capital argument and make an appropriate referral on. In terms of the process within the legal aid agency, once a caseworker identifies that a trapped capital argument has been made, they then refer the case on to one of the technical leads, one of whom is myself, and we will try and turn around the emails that we receive within about half an hour, basically. So we do prioritise any trapped capital referrals that we receive, and then we get back to the caseworker either saying yes, it's fine for the asset in question to be assessed as having a nil value, or on occasions we'll need to seek some further information from the solicitor making the argument, and the caseworker will do that. All the trapped capital argument cases are now logged, so we've got ideas in terms of volumes as to how many we get. And as an example, in May 2022, we had 26 trapped capital arguments received, and we granted all of those claims or arguments. On probably 5 or 6 of them, we did need to seek further information, but once we got that information, we did grant the trapped capital argument and assess the asset in question as having nil value. In terms of additional guidance, you can use the application fixer address, which is applicationfixer@justice.gov.uk. Ideally, we'd like you to use that address if you can see that a caseworker has made an obvious error on an assessment, which can be corrected quickly. My colleague Dave Moore basically deals with the emails that come to that address usually. You can also use that address if the LAA ask you an error for documentation that has already been submitted and uploaded. So that's the address to use in that instance.